You were driving directly at Mr. Taylor and his bike because, as you stated, you wanted to hit his bike, right?
I wanted to disable the bike so he couldn't get away.
And you wanted to disable that bike by hitting it with your car.
Yes, the rear end tire of it, yes.
Not only was there no arrest, Mr. Jones didn't even get a ticket, right?
That's correct.
Okay. Now, Charles Jones, he ran over my client with his car. And the DA's office, they turned a blind eye to attempted murder committed right on their doorstep. And together, they want you to run over justice with your birth. When Charles Jones tried to kill Mr. Taylor by mowing him down with his car, he was angry. He feared being charged with attempted murder, and he made false, inconsistent, and implausible allegations of menacing to avoid being arrested for what he did on camera. He concocted a story that changes every time he tells it, a story that is not backed up by the DA's security camera surveillance footage, a story with no corroborating witnesses. Once again, Charles Jones decides to escalate the situation as far as it can go. This time by mowing Mr. Taylor down with his car. He flips his car around, and it's at this point that Mr. Taylor becomes extremely afraid. Afraid that what started out as a simple traffic dispute could now end his life. He runs to his bike for dear life, but it's too late. Charles Jones speeds right away through the stop sign on the opposite side of the street, and the DA's office is right there, blocking your view of oncoming traffic. But Mr. Jones didn't care about oncoming traffic. He speeds right through the stop sign and goes straight into oncoming traffic against the one-way that he was so upset about. And he plows right into Mr. Taylor. He didn't hit the bike. He hit Mr. Taylor. And his bike and Mr. Taylor, they both go flying through the air about 15 feet down the street. And Charles Jones drives off and flees the scene. The DA tries to say he goes home and calls the police. That's called fleeing the scene and nothing else. No charges for Mr. Jones, right? He stands here, a free man, wasn't even arrested that day, wasn't even given a ticket for running someone over. At the end of this trial, there's only one verdict of law support, and it is not.
Mr. Welser, you may call your first witness.
Thank you, Your Honor. People would call Charles Jones to the
Right.
stand.
Right here, sir. Yep. Swear or affirm on penalty of perjury, the testimony you're about to give is the truth.
Yes, sir. I do.
You may proceed, Mr. Welser.
Thank you, Your Honor.
My name's Charles Mitchell Jones, and Jones.
And Mr. Jones, tell us a little bit, how long have you lived in Pueblo?
12 years now.
And are you familiar with the area around the DA's office?
Yes, I am. I live half a block from there.
To drive that quite often then, I'd assume?
Yeah, every day.
So I'd like to point your attention then to the morning that we're talking about, October 1st of 2025. Were you driving home on that morning?
Yes, I was. I was coming home from Carl Jr.'s. Well, I pulled up to the stop sign. I stopped. Now it's one way, so at first I looked to the left because I was always trained, look left and right and left. This time, no, it's one way. I looked to the right more because there's 3 lanes. They're all going, south. So as I'm looking there, when the guy came by, when I first looked, you couldn't see anything with lights. Everything was dark. He was on one of those little e-bikes, hauling butt, I guess about 20 miles an hour. All of a sudden, he's right in front of me. Now, when we turn the thing on, you'll see, I don't see him or lights because I don't see him until he's right in front of my car.
Were you expecting to see someone coming from
No.
that direction?
I was scared because I almost hit him and I was afraid I would have hurt him. I don't run people over with my butt car.
And so then you get the stop sign, you look both ways and you didn't see anyone. What did you do next?
Well, first of all, I did not put my window down. My window was down from going to the thing.
Well, we'll get to that,
Okay.
but so at the stop sign, you see someone come over in front, what happened?
And I stopped and my car stalls. It will not crank.
You had kind of yelled at him that he was going the wrong way. Was your window down at that time?
Yes, it had been down since I'd been at the restaurant.
Okay, so your windows were already down.
It was a hot night. And then when he gets up to the car, he kind of comes up and real quick and puts his head in the window. Well, yes, I did try to poke his eye like the Three Stooges, because my two fingers, because he put his head right there on me. And he backed up, and then that's when he went for they had like this pouch or something, or I don't know, couldn't tell, but he started doing this. And then he called me motherfucker again. He says, now motherfucker, what are you gonna do? And he takes out this pistol. And I wasn't looking for the color of the time, because all I saw was the 9mm bore pointed right to my face, inside my car.
And when he did that, how did you feel when he pointed the gun at you?
Time slowed down. I mean, what might have been 30 seconds seemed like 3 minutes. And as he's doing this, I grabbed the gun and his wrist and pinned it against the chain, because he says, motherfucker, give me your wallet. But I hit the gun like that and pinned it against the wall.
And
And
then-
I came, I hit the rear of the bike, like the police do in the videos where they hit the tail end of a car or something, make it spin. I did not run him over, or he would be dead.
And so what was your reasoning then for kind of making the U-turn in?
Because he
Tossed into his
just put a gun in my head. I'm not going to reward somebody and let somebody get away with that. I was in the Army during the Vietnam War.
Objection,
and
Judge.
Okay, never mind.
Sustained.
I
Sorry.
would strike that last.
My whole life, I've always stood up for
Okay,
myself.
Mr. Jones, please, when there's an objection and the court is ruling on it, you have to stop talking.
He walked up to your passenger side window, right?
Yes.
At no point did Mr. Taylor ever come around that driver's side.
No. He could do what he was doing through the window.
Mr. Jones,
Yes.
I'm going to ask you to answer the questions.
Well, ma'am, I'm best evidence. I was there, and you don't want to believe anything I say.
Judge, may we approach?
Yes.
Thank you.
Response to the question that is asked, okay? So, Mr. Jones, don't comment on the question or argue with counsel. Counsel asks a question, a specific question. Usually it's a single subject question with a short answer, yes or no. And you are to respond to that question.
And when you were speaking with officers, they asked you about that gun, right?
Yes.
They asked you what it looked like.
I told him it looked dark because his hands were around it, and I couldn't see, but the barrel looked dark blue, like a barrel does. And I'm looking down the hole, not at the gun color. And then he asked me later, I said it might be brown, not yellow. But
Mr. Jones, you're getting ahead of me here.
Okay, sorry.
The question I asked you was that the officers asked you what the gun looked like.
And I told him that it was an automatic and.
Mr. Jones, the officers asked you what the gun looked like,
Yes, they
yes
did.
or no?
Yes,
When the officers asked you what the gun looked like, you told them it was blackish blue, correct?
well, that part I could see was blackish blue, yes.
So when they asked you, that's what you told them.
Yes,
Okay. You then claim that after Mr. Taylor used two hands inside of your car to hold a gun to your head, you knocked the gun away, right?
no, I didn't say that at all. I said that I pinned both his hands because if he'd had one gun and I pinned it, he still had a free hand, but he did this, and when he did that, I got both hands pinned against the car real quick. And since I'm in my car doing this, I could put pressure on it and hold it there.
So it's now your testimony today that you pinned Mr. Taylor's two hands with your one
That was
hand.
the testimony from day one. It hasn't changed, not one word.
Mr. Jones?
Yes,
It is your testimony today that you used one hand to pin both of Mr. Taylor's hands
yes,
in the
ma'am.
car.
And it's true. When I was in college, I bench pressed 450.
Mr. Jones,
Well, you're
Please.
acting like I didn't do what I said.
Judge, may we approach?
Yes.
Sorry.
Thank you.
So the witness is reminded, Mr. Jones, I'm just going to, this is called an admonishment, okay? I'm going to remind you again that you were to answer the question that is posed.
Now, that's not the only time that you claim Mr. Taylor pointed a gun at you, correct?
I don't understand.
Well, you claim that Mr. Taylor pointed a gun at you again as you were driving away, right?
I never said that.
And so it's your testimony today that you never told the officers that Mr. Taylor actually pointed the gun at you a second time.
I said that he still had the gun in his hand and I was afraid. But I didn't say that I specifically saw him actually point the gun at me.
Judge, permission to admit and publish Defense Exhibit A1.
Granted. So the exhibit is displayed. Members of the jury, can you see that okay? All right.
And just to orient you, up there in the top left corner, you see those lights?
Yes.
Your headlights, correct?
I can't tell. I don't know where this, what's this 7th Street? Okay.
Are you able to see it okay on the screen?
Yeah, I can see the light, but I can't tell what's behind it. Yes, that looks like my car.
So that video we watched was of your car pulling a U-turn, correct?
Yeah, correct.
And you were able to see that you pull that U-turn kind of in the middle of a road.
Right. Which is 7th Street, I think.
That was us watching your car pull back out into the street after pulling the U-turn, correct?
Correct.
You're pulling onto Court Street,
Correct.
right? You're pulling the wrong way onto Court Street.
Yes.
You just watched yourself pull onto Court Street without stopping, right?
Yes.
Without looking to see if there was oncoming traffic.
Well, I looked and I didn't see lights or anything. It was dark and no traffic.
You just watched yourself pull into the road without stopping.
But ma'am, the car didn't stop. I agreed to that, but I did look.
And after you pulled out onto Court Street, you actually started to accelerate, correct?
Yes, a little bit, yes.
I believe on direct examination, you estimated that you were going about 25 miles an hour.
Yes, I guesstimate.
And you pulled that U-turn and you drove the wrong way down Court Street because you were driving towards Mr. Taylor, right?
Yes, I was driving towards some motorbike.
And you were driving directly at Mr. Taylor and his bike because, as you stated, you wanted to hit his bike, right?
I wanted to disable the bike so he couldn't get away.
And you wanted to disable that bike by hitting it with your car.
Yes, the rear end tire of it, yes.
And you actually did hit Mr. Taylor's bike, right?
Yes, the rear tire.
And at this time, I would ask for permission to admit and publish Defense Exhibit A2.
Any objection to A2?
No, you're not.
Okay. A2 is admitted and you may publish.
We just watched a video of you hitting Mr. Taylor's bike with your car, correct?
Correct.
You could see the bike in that video move after it got hit.
Yes.
You can see Mr. Taylor move after you hit him in his bike, right?
Yes. I saw the bike slide undercut his speed, yes.
After you hit Mr. Taylor's bike, you actually stopped your car for a second there, right?
No, not stop, no. I mean, there might be a half a second before I pulled off, but I hit the rear, it slid there, hit the curb, he fell down, he got back up. I drove off because I wanted to go get the police. I started to go to the 7-Eleven, but I changed my mind and went home.
And Judge, at this time, I would object to non-responsive and move to strike the rest of that answer.
Okay, granted.
That last bit that we saw was you driving away from Mr. Taylor, right?
Yes,
Continuing to drive the wrong way down Court Street.
yes,
You did not stop to see if Mr. Taylor was okay after you hit him and his bike with your car.
no, I did not.
You just continued to drive deliberately away from the man you had just hit with your car, correct?
Well, I drove cautiously away to my house to, yes.
So to answer my question, you drove away from the man you had just hit with your car.
I did not hit a man with my car. I hit a bicycle and knocked the rear tire off. There you go again, saying something that's not accurate to me. Why?
And Judge, I'm going to move to strike the rest of that answer as non-responsive.
Granted.
Thank you. And we're talking about the damage to your car because you actually want Mr. Taylor to pay to fix it, right?
That isn't true. They approached me and said, as a victim of a crime, that you could get your car windshield fixed and that dent may be done or touched up. They approached me. I didn't go asking for any money from anyone.
So it's your testimony today that you only wanted Mr. Taylor to pay for the damage to the windshield of your car. Is that what I'm understanding?
That's what I originally told them. And they said that you could probably get the car fixed, paint or something. And I said, well, really? And they said, yes. So I just filled it out. I had a couple low estimates given. And they said to fix the car would be around $800, $800 or $900. That's what they said at their shops and stuff. So that's what I told them at the victim impact statement, which they asked me to fill out.
Directing you back to the question that I asked. Your testimony today is that you wanted Mr. Taylor to pay for the damage to your car. Yes or no?
I said, if he's found guilty, yes.
Despite the fact that you hit him on purpose.
I stood my ground to the best I could by who I am as a person.
Mr. Jones, the district attorney just asked you some questions about the restitution statement you were asked to fill out, correct?
Correct.
You'd recognize a copy of that statement if you saw it today?
Yes.
Thank you. Permission to approach?
Granted.
Mr. Jones, that's Defense Exhibit D. That's the statement of restitution that you filled out in regard to
This is
this
my
case.
handwriting and I filled this out, yes.
Okay, took the words right out of my mouth. So you recognize that document.
Yes.
It looks the same as the last time you saw it.
Yes. $900, that's about what I wrote down. I originally was gonna do 800, but they said, do what it'll take to fix it, so I put 900.
You also included damage to the power steering system, correct?
Yes, which I already fixed.
And you also included, as you stated, money to repaint the car.
Yes.
No further questions.
All right.
But may I add something?
No.
May he ask me a question?
No, no. Okay, Mr. Jones, you may step down.
Thank you very much.
You're welcome.
And Mr. Taylor did not leave the scene, right?
He did not.
And Mr. Taylor called 911, right?
He was one of the callers, yes.
And Judge, I'm gonna ask to admit and publish the 911 call.
I was hit by a car on my bike.
Okay. Are you injured? Have you drive
I
it home?
don't, ma'am?
Yeah, I'm gonna get somebody to you, okay?
So let's go over this, right? You saw footage of Mr. Jones running into Mr. Taylor with his car, right?
Sure.
And
Yes, sir.
Mr. Jones, not in those words, but he admitted it wasn't self-defense, right?
I don't think I'm going to agree with you because he described it in a different way.
Mhm.
But he didn't say self-defense exactly.
Right. And yet you didn't arrest Mr. Jones at the apartment complex that day, right?
That's correct.
Not only was there no arrest, Mr. Jones didn't even get a ticket, right?
That's correct.
Charles told you that Mr. Taylor pointed the gun at him twice, correct?
I don't 100% recall, but I know that the gun was pointed at him. I just don't remember the twice part right at the top of my head. Sorry.
Right, you're fine. So there's the time where he alleges that Mr. Taylor pointed the gun at him in the car,
Yes.
right? But he also said that, he said, and then I started to go away, and then he looked at me like that and pointed the gun at me. And then for some reason, I turned around. Do you remember him saying that?
I don't recall that exactly being
Okay.
said.
Would you recall if I showed you your body worn?
Yes, I would appreciate it.
You know what color it was or anything? It was blackish blue. What I did, I don't know if it was right or not, but I knocked at the gun up like that and I floored it and hauled ass. And then I started to go away and then I started to go away and then he looked at me like that, pointed the gun at me, and then for some reason I turned around.
So that was, he said that he pointed it at him and then he turned around, right?
Correct.
Okay. He never said that he held it against the window, right?
No, not that I can recall.
Okay. But he had multiple points of contact with this gun, right? It was put to his head, he said. He said he swapped it, right?
Yeah, I guess you can describe it that way. Yes.
Okay. So he may have touched it with his head, right?
If it was put directly on his head, yes.
Okay. He may have touched it with his hands, right?
It's correct.
Okay. And in this case, you never did what's called a GSR kit, right?
No, I did not.
Okay. And a GSR kit is a gunshot residue kit, right?
Correct.
Now, those are typically used in, probably way more serious cases, right?
Yes,
Where a gun is actually fired, right?
it's correct.
But sometimes gunshot residue can be present even when a gun isn't fired, right?
Yes, it's correct.
Okay. So if you had done that kit potentially with Mr. Charles or Mr. Jones, right? You could have swabbed his head to see if there was any GSR there.
I guess, yeah.
Yeah. You could have swabbed his hands to see if there was any GSR there,
Sure.
right? And that wasn't done, right?
That was not done.
Okay. And no prints were taken, right?
Not that I'm aware of, no.
No swabs for DNA, right?
Not that I'm aware of,
Okay.
no.
In real life, deliberately driving your car into somebody is a crime. Fleeing the scene after you deliberately hit somebody with your car, that is also a crime. These are two crimes that were committed on the doorstep of the district attorney's office. And Mr. Walter is completely correct when he told you that Mr. Jones is not the one on trial here today. And we know exactly how Mr. Jones might be affected by this verdict. He's hoping to be $900 richer because he submitted paperwork asking for Mr. Taylor to pay for the damages to his car caused when he deliberately ran it. And he wanted to go back and forth on whether some of that damage existed from before this day or from this day. But either the damage to the car was caused by him making a choice to run over Mr. Taylor, Or it was damage caused from before this day, and he submitted a false claim asking Mr. Taylor to pay for damages that had no relation to him at all. He stands to gain money from the verdict in this case, and you are allowed to consider that when you consider his testimony. Part of that made-for-TV story is that Mr. Taylor tried to rob him. He held him at gunpoint to try and steal his wallet. This officer testified, Officer Proctor told me that when he spoke to Mr. Jones, there was no mention of a wallet. There was no mention of a robbery. There was no mention of those things because those things did not happen. That is a tidbit that Mr. Jones decided to add especially for you so that you would try, so that he could try and get you to believe sworn to yourself. Because when you think about what things happen on TV, you think about the guys on alone late at night. Think about the random hooligan that comes up unprovoked for no reason, sticks a gun in your face and says, "Give me your wallet." That's TV. That's not real life. That is Mr. Jones' allegation, and it is false. The reason he is there is because the officers in this case didn't move the investigation. They got it wrong. They did not apply the right level of scrutiny to what Mr. Jones was telling them about.
All rise for the jury. All right, dispensing with the caption, the jury verdict form reads, "We, the jury, find the defendant, James Larry Taylor, not guilty of count number 1 menacing, signed by the jury foreperson. Judgment of not guilty is entered, defendant is discharged, and bond is released."
And Judge, I would ask that the motion for restitution be denied.
Okay, Mr. Walser,
I think it's moved, so I don't think any action is necessary.
I would agree. The motion for restitution is denied. Defendant was found not guilty. So restitution is denied and closed.
Thank you, Judge.
All right, thank you both.